European Convention on Human Rights an instrument for change? In the interview, Dean Spielmann, President of the European Court of Human Rights.
Mr. Spielmann, you've been a judge here at the Strasbourg court for 8 years now. Which case has been the most exciting for you? Which case has moved you most personally?
Well, it's very difficult to point out one specific case. There are many, many cases which are very important. I've been proud to participate in the judgment of those cases. Just to give you one or two examples, Saldus against Turkey was one of the most important cases concerning the rights of defense and the rights of the accused to be assisted by a lawyer during his first interview. Another case, of course, concerns anti-terrorist legislation, Sadi against Italy, where the court emphasized that under no circumstances a person can be ill-treated, even if it takes place in an anti-terrorist context. The right not to be subjected to inhuman treatment or to torture is an absolute right which can under no circumstances be undermined.
Let's take a brief look at your formative years. How did your interest in human rights develop?
Well, I studied public international law at university, and of course the European Convention of Human Rights is one of the most important treaties in international law. As a practicing lawyer, I practiced criminal law. I was teaching criminal law in universities, so it was quite natural for me that human rights became one of the most important subjects. And I'm very dedicated, I've always been dedicated to the protection of human rights. So that might be one reason why I eventually became a judge here at the European Court of Human Rights.
People might think that you inherited it from your father, who was also a judge here at the Strasbourg courts decades ago.
Yes, it is true. My father has been a judge here at the European Court of Human Rights. As a national public prosecutor, he has always been very dedicated to the rights of detained people, prisoners' rights. So it is clear that I have been influenced to some extent by my family tradition.
Your biography names music as your special interest. Which composer, what kind of music do you like most?
Well, I prefer, of course, organ music because I play the organ myself, and of course Bach is one of my favorite composers, but I like very much English organ music also.
You wrote an article on music and human rights. Could you please sum up the relationship between the two?
Well, I think there is a clear link between music and human rights. Freedom of expression is probably the most relevant provision of our convention concerning music. But music can also be a threat to human rights, and for instance, if music is abused to torture people, this may become a problem. So there are both aspects, human rights, freedom of expression, music in the context of freedom of expression, but also music as a threat, as recent events have shown us.
Mr. Spielmann, citizens from 47 countries, from Portugal to Azerbaijan, can directly appeal to your court here in Strasbourg. Which countries submit the most complaints?
Well, there are about 5 countries which have many, many applications pending here at the European Court of Human Rights. Ukraine, Russia, Turkey, also Romania, Poland were the countries where we got most of the applications. But I would like to emphasize that every country might have problems concerning human rights, including small countries from time to time face problems, and we deal with those applications also.
More than 100,000 cases are pending here at the Human Rights Court. How can a single court ever cope with such an amount?
Well, we have done huge efforts, especially last year, and this year we have increased incredibly our productivity. Thanks to our policy of prioritization. We take the most important cases first, and then we deal with the other applications, but also by increasing the efficiency of the filtering section in our court. dealing more efficiently with applications which present no merit whatsoever. So the result is very, very encouraging, but lots needs to be done, and I'm thinking especially about the repetitive applications, what we call the very well-founded cases, where we need to find solutions to deal efficiently with those applications. I would like to add that it is a primary responsibility of the member states to implement our convention and to apply and to interpret the convention. And if member states do their job efficiently, we will get less applications in future.
Let's take a closer look at these reform achievements you just mentioned. Right now there are some 20 judges from Russia working in the registry, filtering the cases. Means they decide on their own behalf whether a case from Russia will be taken to this court or whether it should be shut down.
No, those lawyers work in the registry under the so-called secondment scheme, which means that member states, and it is a very big support for our court, send young judges to the court to assist the judges of the European Court in dealing with the cases. But the judges of the European Court decide on the cases with the assistance of the registry, and the judges mentioned under the secondment scheme assist the judges of the European Court of Human Rights.
So you're confident that they send you the right people, the trustworthy people?
Absolutely. We have strong safeguards within the system to be absolutely sure that the young lawyers assist the court loyally and according to the principles, and the results are absolutely positive. We don't have any problem concerning improper behavior. On the contrary, we are really happy to have such an efficient registry in our court.
If you look into the near future, what needs to be done to make the court more efficient? What will you as president campaign for?
Many countries support the court in a very efficient way, and I would like to emphasize that, for instance, Germany and Austria support the court by making donations to the special account, which is a very important support for the court, but also by sending young lawyers to the court under the secondment scheme. So we would like member states to follow the example and make donations to the special account and support the court also by sending young lawyers helping us.
Before you were elected to the helm of the court, you were serving in the Senate that examined the Yulia Tymoshenko case. I think one needs to explain it a bit. It's the former Ukrainian prime minister who claims that she has been convicted for political reasons and wrongly imprisoned. I would like to ask you, what is it like to deal with such a political high-voltage case?
Well, you must understand that I cannot comment on a pending case. The Tymoshenko case is a pending case, but it is, of course, one of our jobs to deal with cases that have also political consequences. I would like to emphasize that we do not examine cases according to political considerations. We judge the cases according to the law. But this does not mean that our judgments have political consequences. And I'm particularly thinking about implementing judgments, which is a very important feature of the system.
But you're operating in the political sphere. And I wonder, let's stay for a moment with the Tymoshenko case, whether there has been the political influence, whether, for example, there were phone calls from Kiev.
Well, you must understand that I cannot comment on the Tymoshenko case. This is a pending case, as I said, so I will not comment on this case. And it is clear that many cases are sensitive cases, but this is, again, inevitable in our court.
What role does the court play in Europe? What's the political significance of that institution?
Well, the court has changed everyday life. I think that's the most important achievement of our court here in Strasbourg. I'm thinking about the rights of the accused. I'm thinking about prisoners' rights. I'm thinking about minority rights. In all those different areas, the court has changed everyday life. That's a major achievement of our court.
but an achievement which is not undisputed. Critics, especially in Great Britain, say the court broadens its jurisdictions in a manner that interferes with our national issues too much. How do you respond to it?
Well, I cannot agree to these critics. Our court, according to our case law, interprets the Convention as a living instrument. The Convention needs to be interpreted in the light of changing circumstances in Europe. It is clear that judgments of our court sometimes prompt criticism, but this is again inevitable.
Conservative politicians in the United Kingdom even question the legitimacy of Strasbourg. Do you fear Britain might withdraw from the treaty, from the convention that forms the basis of the court?
I really hope that Britain will not withdraw from the system. Britain has a long tradition of abiding with the rule of law. I would even say that Britain is one of the countries that took the initiative of instituting the whole system. Many famous British international lawyers were at the origin of the system of the convention, and I'm very confident that in the end the rule of law will prevail and our judgments will be implemented according to the principles of public international law and according to the principles of our convention.
I know that judges do not like iffy questions, but in case that it would happen, if Great Britain withdrew from the courts, how far would it damage the institution?
Well, it would be a disaster, to be honest. All countries here in Europe have adhered to the system except one country. But the 47 member states of Europe show that there is a space, a European space, where civil liberties and fundamental rights are respected. So I cannot imagine that one state will withdraw from the system. It would be a political disaster.
Dean Spielmann, President of the European Court on Human Rights, thank you very much for joining us on Deutsche Welle.
It has been a pleasure. Thank you.